Welcome back to Artificially Informed, the podcast series that offers an in-depth look at the Florida Attorney General's Government in the Sunshine Manual, 2025 edition. I'm Joel Chandler, and as always, this episode is produced with the extensive use of artificial intelligence. I write the prompts and meticulously review and edit all of the output. In today's episode 7, we're taking a deep dive into Part 1, Section C of your manual, specifically Notice and Procedures. We'll be navigating pages 40 through 55 of your manual. Our discussion will go into significant detail on agenda requirements, meeting locations, minutes, and the public's right to attend and participate. Because we're covering these topics with extra granularity, this episode will be longer than our usual 15 minutes. Let's begin by exploring what public bodies absolutely need to tell us before a meeting even happens. Segment 1. Notice requirements and agenda content. Starting on page 40, we'll talk about notice requirements and agenda content. The core idea here is that for a public meeting to be truly open, the public needs to know when and where it's happening and what's going to be discussed. It's not enough for the door to just be unlocked. There has to be reasonable notice so you can actually show up if you want to. What exactly does reasonable notice mean? Well, the manual clarifies that there's no single, one-size-fits-all rule for every public body. It really depends on the type of body and the nature of the meeting. However, the courts have consistently interpreted reasonable to mean that the notice must be given far enough in advance to allow interested members of the public to attend. For example, in Yarborough versus Murphy, 458 Southern 2nd, 783, Florida 5th District Court of Appeal, 1984, the court stressed that the timing and method of notice must be sufficient for the public to become aware of the meeting. It's not just about technical compliance, it's about the spirit of openness. Typically, this means regular public bodies like city councils or county commissions post their meeting schedules and often their agendas in advance in public places, on their official websites, and sometimes even in local newspapers. For special meetings or workshops, the notice might be shorter, but it still needs to be reasonable under the circumstances. The goal is to avoid surprise meetings where significant decisions are made without public awareness. Now let's talk about the agenda requirements, also on page 40. The notice isn't complete without a clear idea of what's on the agenda. The agenda doesn't have to be a word-for-word script of every little thing that might be discussed, but it definitely needs to be clear enough to inform the public about the general topics, and especially any official action or significant policy decisions that might be made. The manual emphasizes that general terms like old business or new business are usually not sufficient for items that require official action. If a board plans to vote on a budget, hire a new department head, or make a major zoning change, that specific item needs to be clearly listed so the public knows what's coming. As the court stated in Telesco versus Florida Elections Commission, 753 Southern 2nd, 581 Florida, 4th District Court of Appeal, 2000, the notice must be sufficient to provide meaningful opportunity for the public to attend and be heard. What if the agenda needs to be changed? The manual covers this too, generally stating that significant changes to the agenda, especially if they introduce new items for action or major deliberation, should ideally be renoticed if time permits, or explained clearly at the start of the meeting. Emergency meetings are an exception, but even then, efforts to notify the public must still be made. The case of Port Everglades Authority versus International Longshoremen's Association, Local 1922-1, 652 Southern 2nd, 1169, Florida 4th District Court of Appeal, 1995, reinforced the need for agendas to reflect actual deliberation, not just formality. Segment 2, Meeting Locations and Public Attendance. Moving on to page 46, we delve into meeting locations and the public's right to attend. The Sunshine Law demands that public meetings are held in places accessible to the public. This isn't just a suggestion, it's a fundamental requirement. What does accessible mean here? The manual clarifies that it means The location must be physically open and reasonably convenient for members of the public to attend, observe, and hear the proceedings. This means avoiding private residences, exclusive clubs, or locations that are too small to accommodate anticipated attendance. The Florida Supreme Court, in Board of Public Instruction of Broward County versus Duran, 224 Southern 2nd, 693, Florida, 1969, famously stated that the public's right to be present must be reasonably convenient. This implies not just physical presence, but also the ability to meaningfully participate if public participation is allowed. This principle also extends to ensuring that facilities are accessible to individuals with disabilities in compliance with the Americans with Disabilities Act, a federal law that ensures people with disabilities have the same rights and opportunities as everyone else. Agencies must provide reasonable accommodations to allow individuals with disabilities to attend and participate in public meetings. This could include providing accessible ramps, sign language interpreters, or assistive listening devices if requested. The manual also discusses what happens if a meeting location needs to change unexpectedly. Even in such cases, the public body has a duty to make reasonable efforts to inform the public of the new location. This prevents public business from being conducted in an obscure or hidden place. An early example, City of Miami Beach versus Burns, 245 Southern 2nd, 38 Florida, 1971, highlighted that access should not be impeded by an inappropriate or suddenly changed location. As we touched on briefly in Episode 6, the rise of virtual meetings introduces new aspects of accessibility. While physical presence might not always be required for board members, the public still needs a robust means of access. The manual emphasizes that virtual meetings must provide clear interactive access for the public, whether through a public viewing location equipped with technology or through their own devices at home, provided the instructions are clear and the technology is reliable. The goal remains constant: no secret gatherings, regardless of the medium. Segment 3, Minutes and Public Participation. Now, turning to page 51, let's discuss minutes and the public's right to participate. The Sunshine Law doesn't just demand open meetings, it also requires a clear public record of what transpired. This is why public bodies are universally required to keep minutes of their meetings. Section 2, 86.011, subsection 2, Florida statutes, explicitly states that the minutes of a meeting of any such board or commission shall be at all times open to public inspection. This legal mandate ensures accountability by providing a permanent official record of governmental action. What should these minutes contain? While they don't need to be a word-for-word transcript, they must accurately reflect the actions taken, including the date and time of the meeting, the members present and absent, a summary of the topics discussed, all motions made, the identity of the person making and seconding each motion, the vote of each member on every motion, the outcome of each motion. The manual notes that while agencies may keep more detailed recordings like audio or video, the official minutes are the written record. These minutes become a public record themselves upon creation, even in draft form, and must be made available for inspection and copying, subject only to very limited exemptions. The courts often review minutes to understand the official actions of a body, as seen in Wood versus Marston, 442 Southern 2nd, 934 Florida, 1983, where the court scrutinized how decisions were documented. Any corrections or approvals of minutes should also happen in an open meeting. Finally, while the Sunshine Law mandates open meetings, it doesn't automatically guarantee a right for the public to speak or actively participate at every meeting. The public's right to attend is absolute, but the right to speak is generally left to the reasonable rules and policies of the local public body. Many boards do allow public comment periods, and they can set reasonable time limits or other rules for participation. However, they cannot use these rules to suppress speech or prevent citizens from addressing relevant topics. The line is often drawn between allowing reasonable public input and ensuring the board can conduct its business efficiently. This concludes our in-depth exploration of notice and procedures under Florida's Sunshine Law. We've covered a lot of ground, from the essential elements of informing the public to the detailed record-keeping requirements. Thanks for listening. In our next episode, episode 8, we'll conclude our look at the Sunshine Law by discussing exemptions and enforcement, starting on page 56. Until next time, remember, the truth dies in the dark, so let's leave the light on.